Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now see the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everybody. Welcome to the Appeals Court. This is the June 6th sitting. We have only 3 cases on for this morning. My name is John Englander. To my right is Justice Toone. To my left is Justice Wood. We will be the panel for all 3 cases this morning. And I think we have experienced advocates in front of me, but just so you know the rules, 15 minutes to the side. There is no rebuttal. We will be prepared. We will have lots of questions. We have 3 very interesting cases on for today. And so I urge you to get right to the point. And with that, we'll call the first case, which is Commonwealth against RAFAEL Nunez. And the number is 24P1211. Mr. Crane.
Good morning. May it please the Court. Edward Crane on behalf of Francisco Nunez. The primary question in this case asks, what are the essential elements of a possessory firearm offense under a joint venture theory of liability in the aftermath of the SJC's decision in Commonwealth v. Guardado? Prior to Guardado, the Commonwealth was not required to prove the principal's lack of licensure unless the defendant raised it as a potential defense. That is no longer good law as a result of Guardado. To prove a possessory firearm offense under a joint venture theory of liability, the Commonwealth must now establish the principal's lack of licensure and that the defendant knew the principal was not licensed.
This case was tried post-Guardado 1, am I right? By about 2 months?
Yes.
Okay.
But so the Commonwealth concedes, I think, that piece of your argument, right? The Commonwealth concedes, I think, that joint venture is a no-go in this case because of the failure to instruct the jury that your client had to know that the other guy had a license to carry to convict on the joint venture theory. So I don't think there's much argument there. I think the much more difficult question is the alternative constructive possession argument. So tell us why we have to reverse, given the possibility that the likelihood that the jury convicted on constructive possession.
I think, first off, I have to address the Commonwealth argument in this respect, and that the Commonwealth argues that basically because there was sufficient evidence of constructive possession, that negates the error with respect to the instruction on joint venture. And I would posit that is not the standard. The standard is not simply that there was sufficient evidence. I think the standard has to be, and this comes from the Desiderio case, was the evidence so overwhelming that it made it sort of, I guess they used the word, ineluctable or inescapable inference that the omitted elements would have been established. So obviously where this case gets tricky
I'm lost a little bit. I mean, I understood your argument to be that if the instruction was incorrect on one of the 2 theories that was presented to the jury, the case has to be, the conviction has to be vacated. Isn't that the argument? What case would you rely on for that, by the way? In other words, even if there's sufficient evidence that your client could have been convicted of constructive possession as a principal, okay, because the jury was instructed on an alternative theory of joint venture, which was incorrect according to you, the case has to go back. Isn't that the theory?
Well, I think we do have to get to a second step, which is because if...
Really?
Maybe not.
You have to get to a second step? If you've got 2 theories presented to the jury and one of them is wrong, the verdict can still stand?
Well, I think the only way the verdict can stand is if the evidence on that misinstructed theory is so overwhelming that basically the omission of those elements wouldn't have mattered.
Oh, I see. So you're on the ineluctably inferred prong of the joint venture theory. I agree. Yeah, yes. We have to do that.
Are you talking about a substantial risk of miscarriage of justice analysis because it wasn't objected to, or is that why you're talking about this kind of prejudicial? I'm trying to understand the framework of why we have to, assuming that there is a clear error, the Guardado issue as to the aiding and abetting piece of this. We're looking at substantial risk analysis, right?
Yes.
Okay. And that takes into consideration all sorts of things, including the strength of the evidence, maybe as to the alternative theory. Well, I'm asking. I'm not saying.
And I think that's sort of the gray area here is
Okay.
that in a lot of these cases involving an unpreserved instructional error, so it's substantial risk, the court has looked to whether the evidence was such that, and they use that phrase, ineluctable, inescapable inference that the omitted elements would have been established by the evidence.
There was no evidence whatsoever with regard to the principal, right?
Yes.
We don't even know, his name wasn't even put forward, let alone whether he might have had a license to carry a firearm. Right?
Or the defendant's knowledge of that license status about a license to carry.
Yes.
Right. In other words, I think there's no way to sustain a conviction for joint possession of the firearm on a joint venture theory. Right. And the Commonwealth concedes that.
Yes.
Right. Okay.
Yes.
So if we have that, and we had two theories presented to the jury, and one of them was presented incorrectly with respect to the instructions, the verdict can't stand.
I agree.
Well, so
What case do you rely on? Because sometimes I hear a different argument when we're talking about sufficiency of the evidence as opposed to the instructions. What case should we look to for that proposition? Because I didn't see this really discussed in the briefs.
I think the case that I primarily would rely on for the analysis would be Commonwealth v. Desiderio, where the court looks to it's an error in the instruction on joint venture, and the court looks to whether the evidence was such that it would have been an inescapable inference.
It's a different issue, counsel, okay? We just jumped past that issue, all right? I mean, you concede, and I'm going to lay some of my cards on the table so the Commonwealth can get ready. You concede that there's sufficient evidence that the principal of principal liability as to constructive possession, correct? Mm-hmm. So that's the alternative theory.
Yes.
As to which the jury was instructed.
Mm-hmm. Yes.
We have an obligation, I take it, to independently review that even though you concede it? Because isn't the only case that's out there that's even close Jackson?
I'm not aware of the Jackson case, Your Honor.
No, on the question of constructive possession by your client as a principal, there's nothing that shows your client. In fact, counsel for the Commonwealth got up, the prosecutor got up and said, there's no evidence he ever had the gun. And then expressing his personal opinion incorrectly said, in fact, I don't think he did. Okay? So, I mean, we've got a case where, you've conceded constructive possession, but the only person who ever possessed a gun was someone else.
Yes.
Okay. So why are we conceding constructive possession here? Because of the Jackson case, the case where the guy chucks the thing out the window after two people take off in a car?
Well, I would concede constructive possession because, oh man, now you put me in a tough spot here.
Well, I mean,
I have this question too. I don't understand your concession at all, because it doesn't seem that you have to have some kind of exercise dominion of control. And as far as we know, the only evidence is that your client was driving the Ford and that the shooter went in and out of the car. But that's very different from the situation where a gun is found on the floor of the car and it's in the defendant's. I mean, it just doesn't. I was puzzled by the basis for a constructive possession finding here, and I was puzzled by your concession that existed, because that seems like a real problem here. Just to flip back to what I think the Commonwealth's going to argue is they're going to say, well, you look at Zanetti, it doesn't matter what the problem is with the aiding and abetting piece of this, as long as there's a basis for principal liability, then that's enough for us to uphold it. I'm not sure if that's true with respect to instructional error, but assuming that it is, that gets us back to the problem with your concession as to constructive possession, because if you're conceding that, you're conceding principal liability, and that seems unhelpful to where you want to go in this. So can you address one of those issues?
Well, I don't think I've ever been in this position before, but can I take back the concession?
I suspect that's true, counsel.
Yeah, I guess I would, if I can, I'll take back the concession, but if not, I mean, I guess.
Well, I think we have an independent obligation. I'm going to answer your question because I thought about this overnight. I think we have an independent obligation in evaluating the evidence in this case to make a determination on our own as to whether there's sufficient evidence on constructive possession. So I don't know that it matters. If you want to argue that there's not, or if you want to help us try to figure out whether there is or there isn't based on the facts in this case, that would be great. We're going to ask the Commonwealth. I am.
I guess to explain myself probably why I guess I've argued so many sufficiency cases, and knowing that the standard for sufficiency is generally so low, maybe I just jumped to the assumption that that the standard would have been met here.
What it seems to me is different about this is that we know who was holding the gun, and it was not the defendant. So the notion that the defendant possessed the gun strikes me as counterfactual. Okay? He did not have it on his person. Someone else had it on their person. Now, there is this language in the statute that says knowingly has under his control in a vehicle that I don't think anybody's really spent a lot of time with in the case law. And, you know, I'm anticipating what the Commonwealth's going to say, but you want to help us with that? Is there any case that's going to help us? What does that mean? Knowingly has under his control in the vehicle, when the only evidence is that someone else has held the gun.
Well, I know it doesn't require actual possession of the firearm.
That's correct. No question. But what if we know that what if the only evidence is that someone else was holding it?
Right. Isn't it, it's speculative, to pick up on Justice Englander's point, it's speculative to suggest that your client, exercised control. We watch the videos, we see the other fellow holding the gun. We know that the other guy runs into the apartment, we know that the other guy gets out of the car at some point and shoots at the red van. We don't see any evidence that your client constructively possessed the gun. Theoretically, he puts it down, or whether you could speculate about all sorts of things, but it seems like all of it is speculative about the extent to which your client controls the gun. Is that accurate?
Yes.
The jury infer, so from the second, what I'll call the second event, right, which is the attempted murder, where the jury came in, in favor of your client. But watching that, the car pulls up directly next to the other vehicle. That vehicle bolts as quickly as possible. Someone gets out of the right side, which the jury can infer is not the defendant, not your client, and fires a shot at the vehicle, right? Can the jury infer from that your client knowingly had under his control a firearm in a vehicle?
No, I don't think so.
Why not? I mean, what does the word control mean in that context? He's the one who drives the car. Let's assume the jury can infer that he's the one driving the car. He drives the car up, he puts it right next to the other car, right?
Yes.
And then, boom, this guy comes out with a gun in his hand. Mm-hmm. Knowingly has the gun under his control in the vehicle? Is that sufficient?
Well, there are certainly other possibilities.
Could perhaps answer this by saying, that's why I made the concession, Your Honor, but that might not be what we wanted to hear.
I don't think that's the way I want to go anymore.
Help us try to figure this out. There's no case, right, that has this kind of fact?
No, not that I've found.
Yeah, I mean,
I guess that there are.
Other than Jackson, is there any other case that helps us elucidate this question that you're aware of?
Not that I'm aware of. I guess I know that the constructive possession case that defense counsel, we always rely on is Commonwealth v. Romero, because that does seem to be one of the cases where it really goes into depth about constructive possession of a firearm in a vehicle, and they rule in favor of the defendant.
And in Romero, the gun, I think, eventually is placed not in the possession of the person who's handing it around, actually, right?
The defendant in Romero did actually hold the weapon
Earlier in the day.
earlier in the day.
Right.
Yes.
And the court still says not enough.
Not enough, yes.
Yeah, and the test there is you have to have some kind of knowledge, power, or intention to exercise control over the firearm, right?
Yes.
Is there anything like that here? I mean,
No, really, I guess.
well, we'll ask the Commonwealth as well, but I think.
Anything else you want to address? We've asked a lot of questions.
I have a quick question for the justices. Is Commonwealth v. Jackson a constructive possession case?
Yes, it is.
Okay, I will.
My understanding.
And if I review that case and feel like I need to address it, would I be permitted to submit a 16L letter?
We'll confer on that in a moment, but
That's okay.
we can all read the case.
But there is, before we let you go, there's an additional layer here. Accepting that somehow the Commonwealth can get over that bar, whatever it is, low, high, medium, of sufficiency. The question, I think, is still presented whether it's possible, likely, that the jury relied on the joint venture theory instead of constructive possession. And if there is a reasonable possibility that that's what happened, then reversal and remand is necessary anyway. Is that right?
Yes, I think so. I think so. Because this was tried really specifically as a joint venture case, I think that possibility necessitates remand because it really is primarily a joint venture case.
Oh, but as I put the pieces together, it's tried post-Guardado. If there's no evidence that the principal was unlicensed, tried post-Guardado, that claim fails. And if there's insufficient evidence on the principal liability, then the whole thing goes.
Yes, Your Honor.
Anyway,
I do
you want to talk about the 911 call at all? We've asked a lot of questions, and your red light is blinking.
I'll pass on the 911 call, but I do just, before I sit down, I do think it's important, because this has been raised, if the evidence, the court does conclude that the evidence was insufficient to convict him as a principal, then obviously the remedy that I'd be asking for is different. I would ask for a judgment of acquittal, because
Understood.
The evidence would be insufficient. Thank you, Your Honors.
Thank you. And your argument is preserved with respect to the 911 call.
Good morning. May it please the court, Catherine Jansen on behalf of the Commonwealth. I just want to start by maybe outlining the framework of my argument. I think it was maybe not as clear in my brief as it could have been. I'm arguing essentially there's no substantial risk of a miscarriage of justice due to the instructional error, which we conceded as to joint venture, because here there was not only sufficient evidence as principal theory liability based on constructive possession and evidence that the defendant did not have a license to carry a firearm via stipulation, but also the jury was properly instructed on constructive possession as a principal theory, and that the defendant, the Commonwealth need to prove that the defendant did not have a license. I would suggest post-Zanetti, these are not two separate theories or alternative theories of liability. They are, they're just not reviewed separately under the case law.
I totally get your point about so Zanetti seems to say, it's not entirely clear, but it seems to say if there is a sufficiency problem as to the aiding and abetting piece, right? The inquiry for sufficiency is whether there's sufficient evidence that the defendant knowingly participated in the offense, right? And sort of it doesn't require that you actually show sufficiency as to each piece. But are you saying that same kind of analysis applies to an instructional error that clearly renders the aiding and abetting piece of this invalid? Because that's not obvious to me that that's the right kind of analysis here. So can you do you see my point? Sort of.
I understand your point,
Okay.
and I did not really find a case like on this issue. I think, and again, most of the cases I found dealt more with sufficiency. For example, Barry, 431 Mass, 326. Basically, when there's and again, this is required findings, so I understand there's a difference, but when there's insufficient evidence on, when there's a general required finding not guilty on multiple theories, the evidence may still go, the case may still go to the jury if there's sufficient evidence on one of the theories. And Green, cited in my brother's reply brief, is an opposite because that was pre-Zanetti on the, I believe that was an instructional error case.
In the Francis, I'm sorry, just one more quick thing. In the Francis case, we seem to sort of not go down that road. We seem to look at, we treated the Guardado issue and just sort of said, well, we found it harmless in that case, but we didn't sort of say it all kind of folds into the same kind of.
It's not directly on point on that issue because in the Francis case, there was, regardless of the instructional issue, there was sufficient evidence that both the defendant and co-defendant were unlicensed. And I recognize the difference in the cases.
Thank you.
I don't understand why Zanetti helps you if you have instructional error. I mean, if there's, are you trying to say it's one theory? It's not. It's two theories.
But
one theory is you're liable as a principal. Another theory is you're liable as an aider and abettor.
Well, and
if the notion that those two can be conflated, I have never seen in a case, nor do I think it would be right.
Well, I believe the case law shows that they're not alternate theories of liability. It's so long as the defendant knowingly participates with the intent to commit the crime. And so if the evidence is sufficient to show that you are acting as a principal, that's enough to show that you are knowingly participating with the intent to commit the crime. That's what the instruction is. So I think.
Stop for a second, because you're telling me something that I do not understand, and maybe Zanetti says it, and I've just missed it. But you're telling me that Zanetti says these are not two different theories of criminal liability.
Correct. And I would also point, screen, if I could have a moment, Your Honor. So I would point the court to Uberti, 81 Mass App Court. This is an unpublished opinion, but
It's pre-Zanetti, 81 Mass App. It's pre-Zanetti, isn't it?
this is post-Zanetti. It's a 2012 case.
Oh, okay.
It's unpublished. I just found this in preparing for arguments. I apologize, and I understand it's persuasive authority, but it does come from this court. It's 81 Mass App Court, 1130, 2012, Uberti, U-B-E-R-T-I. And, basically says that rather than examine sufficiency of the evidence separately as to principal and joint venture liability, principal and joint venture liability are not separate theories of guilt. And it quotes Zanetti for that at 464 to 465 in Zanetti.
Right. You quote, it's 454 at 466 to 468. It's on page 18 of your brief. You're quoting Zanetti. That case is quoting
Yes,
Zanetti.
yeah.
And, right, that principal liability is not a separate theory distinct from joint venture liability. On appeal, this is quoting from Zanetti, on appeal, after a conviction, we will examine whether the evidence is sufficient to permit a rational juror to conclude beyond a reasonable doubt the defendant knowingly participated in the commission of the crime charged, alone or with others, with the intent required to commit the crime, rather than examine the sufficiency of the evidence separately as to principal and joint venture liability. That's your point, right?
Right.
Right. Okay, but so moving past.
Where are you reading from? Sorry.
Oh, sorry. I'm reading from I'm quoting, it's from in the brief, the red brief at 18. The pin site, it might be 464. It might be at 464. While Justice Englander checks that, if I could then move on to, it still leaves you with the problem that we were all wrestling with.
Right.
Is there sufficient evidence of constructive possession here? And not merely, I think it's not, well, first of all, is there, that's your first hurdle. Is there sufficient evidence of constructive possession where we have no evidence that the defendant actually physically possessed the gun?
I will concede I think this is a very close case on the issue. I would submit, and of course the court can disagree with me, that there is sufficient evidence of constructive possession, where I think the important distinction or important fact in this case is that not only is there evidence that this defendant had the motive to enact some type of retribution based on based on his own admissions about getting beaten up at that party. But the fact that he drove the shooter to 2 shootings, and I think it's a fair inference that when the shooter got out of the car both times, when he was openly wielding those firearms, that he was aware, not only had knowledge of the gun, but had the exercise and ability and intent and exercise and ability to exercise dominion and control over that firearm, because he's driving the shooter to those shootings. And just because it is in somebody else's hand does not render the fact that he can't have constructive possession over it. Of course, you can have joint possession over a firearm as well.
So dominion and control seems like it's doing a lot of work here. Dominion and control. Okay, it seems in some theoretical sense that he might have dominion and control under some set of facts. But given what we know, how do you move, and give me some case law to suggest that you're doing anything more than speculating that he had dominion and control?
So again, this is persuasive authority. This is cited in my brief, Commonwealth v. Edwards, 89 Mass App Court 1126. It's a 2016 case, and in that case, and it's in the back of my brief in my addendum, the court found there was sufficient evidence of constructive possession of the firearm where he drove the shooter to and from the site of a deliberate targeted shooting, sped away immediately after the shooting, remained with the shooter in the car for several miles, and stopped only when pursued and boxed in. So, I mean, obviously the facts are a little different. Everything in sufficiency is very fact-specific, but I would suggest that where you're driving somebody to a deliberate targeted shooting, and in this case it's twice, not even once, that creates that inference of intent and ability to exercise dominion and control.
Okay, so that's unpublished persuasive authority.
Yes, I mean, I recognize that. This was, I mean, I could not find really, that was the closest case I could find.
And so then, we got to look at that, we got to wrestle with that. But jumping over that hurdle, you've got one more hurdle, right? We have to be satisfied, and I'm not really clear about the standard here yet, but that the jury, there's no reasonable possibility that the jury relied on the fatal joint venture theory, as opposed to this constructive possession theory.
And I know Justice Engler does not agree with me, but I guess I would just, and this is the Commonwealth's argument, I recognize that this is an open question of law, or at least based on my research. But I would suggest, because joint venture and principal theory are not separate theories of liability, that if there's sufficient evidence as to principal theory and they're properly instructed, that is okay, and there's no substantial risk.
So the problem with that, now I'm thinking about, I read what Zanetti says, but it doesn't make sense. Here's why it doesn't make sense. Because the jury was improperly instructed then on single theory that was presented to them. Because they were not instructed, not only that if it was principal theory, that his client had to be unlicensed, but they also, and you concede this, and I think it's got to be right, if the theory is joint venture, the other guy had to be unlicensed. They were never instructed on that, but if you're saying it's one theory, apparently, in that one theory, the jury had to be instructed about 2 different theories. If you're going on this guy, see what I mean?
Yeah,
it makes no sense in this context.
I agree. I've also thought about this, and technically, I think, right, based on my argument, it's that if there's sufficient evidence of principal theory and you're aiding and abetting, and you are, and you have the, I'm losing the language from Zanetti now.
Oh, that's right. Take your time. This is hard and it's complicated, and we've all wrestled with it. You know, and help us out. How do we? I've got this language in Zanetti. I see it. Doesn't work here for me, because I think the Commonwealth's concession was correct. That if the theory was joint venture, you had to prove that the joint venturer was unlicensed for a possession case.
And I guess my answer to that is I've been trying to work through this since I briefed the case. It was a difficult case for me to brief, and I've been working through it, preparing for argument. But I think the answer to that is where I would suggest that the jury was not limited to just joint venture liability on the constructive possession issue, because they were never so instructed, that they were so limited by the judge. And I would suggest the prosecutor's closing, or I think it was her closing or opening, I can't remember, basically is not inconsistent with the constructive possession liability. It doesn't foreclose that possibility that.
Okay, but where does, and I can agree, I think, Let's assume we can agree with that.
Right.
I mean, she was very clear that she was concerned about aiding and abetting, but she doesn't foreclose direct liability. But where does that get us here?
Well,
If there was an incorrect instruction with respect to, let's call it, the sub-theory of joint venture liability, how does this stand?
Well, I think it matters because if they're not foreclosed convicting under either theory, even though they're not alternate theories under Zanetti, then I think if there's sufficient evidence as to one or the other, then and they're properly instructed as to the one where there's sufficient evidence, there's no substantial risk because at the end of the day, if you're properly instructed, the evidence is sufficient that you're a principal and they're properly instructed as to that, then you are knowingly participating in the crime with the intent required based on your principal theory liability.
You know, here's the problem.
It's very circular, I mean.
Well, it's not circular, but I don't know that it's circular. The practical problem with it is if we're talking about a substantial risk of miscarriage of justice and the theory that the prosecutor, this is the practical problem. The prosecutor said, look, my theory is aiding and abetting. Okay, I know the guy, I know the defendant never held the gun. And once the prosecutor says that and the jury's not instructed of an essential element of that, which is the guy who held the gun was not licensed, and there's no evidence that the guy who held the gun was not licensed, how is it that we then affirm that conviction?
I think the prosecutor's theory was mainly to the assault of crimes, which I think there's absolutely no evidence that could be solely principal theory part of Zanetti under that. And I think her argument she doesn't have to explicitly state that, and, you know, it's joint venture, but you could also find principal theory based on constructive possession. I mean, would that be more clear and better? And possibly maybe it does make the difference in a substantial risk analysis. I'm not totally sure, but I don't think it's necessary.
Let's just, sorry.
Well, the problem for me is that it's not enough for you, and this is what I hear you to be saying, that it's possible that the jury relied on constructive possession. That's not to sustain a conviction that involves a loss of liberty beyond a reasonable doubt. We need to be sure to some higher degree that the jury relied on constructive possession. And so even if there is sufficient evidence of that, it's not enough to say, yeah, we think they did it, even in the face of an argument by the prosecutor.
I understand your point, and I guess my counter argument would be that we don't know. They get journal verdict slips for joint venture cases all the time, whether it's joint venture or principal theory, and we don't know. So even in cases where we don't know, they were instructed on joint venture and principal, and sometimes, and I didn't find any cases on this, but there could be cases out there. We don't know how the cases don't necessarily say how the prosecutor argued it to the jury, but if there's sufficient evidence of constructive possession, we don't necessarily know if they, in those cases where there's insufficient evidence of joint venture, they might have thought there was joint venture and there wasn't, and that's why they convicted the defendant. But if there's sufficient evidence of constructive possession, then the court upholds those convictions.
Right, but the difference here, and this is hard, but the difference here is that one of the theories is fatally flawed. In other words, those joint venture principal murder prosecutions, it's not that either theory is fatally flawed, it's that we just want to know in a special verdict form which of the two you're convicting for whatever reason. Here, one of them is fatally flawed, and so if the jury relied on joint venture theory, if there's any reasonable chance that the jury, I just made up that standard, but if the jury reasonably relied on, there's a reasonable possibility they relied on joint venture, then I think the conviction is fatally flawed.
I mean, I think that could be said about if there's insufficient evidence of joint venture, and we don't know if they're instructed, even if they're properly instructed on both joint venture and principal, it's a fatal flaw if there's no sufficient evidence of joint venture, but we're going to uphold the conviction if there's sufficient evidence under the principal theory. I see my time is up.
Well, it goes to the point of are these actually different theories? Are there something else? And Zanetti's a little hard for me to wrap my brain around, and it seems even harder here. And I very much appreciate your candor, recognizing the difficulty of this situation. It just does. It can't be the case that any error, some foundational instructional error implicating Second Amendment rights, it washes away because you can establish the defendant's liability more generally. That doesn't seem right to me. But
Understood, Your
Zanetti
Honor.
opens the door to that, at least as sufficiency, and the question is, do we actually go that far?
I mean, as an old appellate person from the federal courts, there's no, I mean, this notion that if you have two different theories and you have sufficient evidence on one of them, that's enough, that wouldn't be, I don't know, does that even fly in the federal courts? It didn't when I was working a long time ago.
Can I ask you one question about the spontaneous exclamation, which I wish our SJC would make a clear rule that it should always be referred to as a spontaneous exclamation, but that's a diatribe that I don't need to spare you. I'll spare you. It's an hour after the event, right?
Correct.
It's an affirmative phone call by one of the people at the party, right?
Correct.
It's a question and answer process. The judge relies primarily on the repetitive nature of the conversation, which is in response to repetitive questions.
I would suggest it's not in response to repetitive questions. I think the repetitiveness, which the judge cited in her decision, there were two repetitive questions, but there were other numerous details that were not asked by the dispatcher.
The SUV, you made that point.
SUV,
Right.
that they were shooting through the door, that was not a question that was asked. It was the question was how many shots twice, and then I think 4 times. He said that, once or twice, and then they were shooting through the door various other times.
Okay. But spontaneity, do you agree with me that spontaneity is, according to the doctrine, according to Wigmore and McCormick, important as a concept?
I mean, I don't think it's just like said. I think the case law is that they're still under the stress of the startling event, which is why I think the courts have, gone between excited utterance or spontaneity of the utterance. I don't think it's just spontaneity.
All right. But so we have the tone from the speaker here. He doesn't seem very excited to me.
You don't need, but the case law is very clear. You can still be under the stress of the startling event without acting hysteric or crying. And I think it's clear based on the content and the tone and the repetitiveness. And I even think the delay could be attributed to the fact that they're viewing this as an ongoing emergency because they had shooting through the door, and then the car that they believed to be associated with the shooter is still outside, and they're worried they're going to come back. And so I think based on that and the circumstances of this case and the fact that the judge did recognize on transcript volume 11, page 7, about the hour lapse, but still thought in this case there was enough. There was no abuse of discretion, even if this court...
They're right downstairs. Please hurry. Sounds kind of spontaneous to me.
I mean...
They're right downstairs. They shot through the door. Please hurry. I don't know.
Right, I'm just arguing some of the counterpoints that were raised by my brother, and want to acknowledge that.
I'm not disagreeing with you.
Right, that's a fair point. That is a fair point. You are both accurately reflecting the record. Thank you for that answer.
I'm happy to answer any other questions the court may have.
I think we have both your arguments. It's a very interesting case. Well argued. Thank you very much.
Thank you.
Yeah, I meant to ask. Do we know what's impounded?
The names of the parties? That's all.
Not the details.
I don't think so.
Of the, no, like fidelity. No, I don't think so. We call the second case if you're ready. Yeah.
Gotcha.
So the second case is Suan against Yousef, 24P 792. And are you Ms. Baskin? Do I have it right?
Yes, I am,
So
Justice.
something's impounded in this case. So this is a reminder and also kind of a question, because are the details of the instruments that we're going to be talking about, are they impounded?
Well, actually, Your Honor, we had asked initially that just the fidelity internal materials be impounded, and Judge Christopher decided to impound the entire matter without distinction. So our understanding is that currently the entire matter is impounded.
What does that mean? We have to have an argument. Are the briefs impounded?
I believe the briefs are impounded, Your Honor. I agree that it's
I haven't filed a motion
problematic.
to close the courtroom. I've not encountered this problem, okay? We have open courtrooms in this Commonwealth. There's been no motion to close the courtroom. I'm going to take it that there's an agreement of all counsel that we can go forward with this argument based on the briefs.
I have no objection to that, Your Honor.
Is that agreed to?
No objection, Your Honor.
Okay, I want to make sure you're on the record on that. Because this case is about the instruments, okay, and the details of these instruments. We don't need to talk about the parties' names, but we need to talk about the details of the instruments to have any kind of meaningful conversation because it's hard, okay?
I agree, Your Honor.
Okay.
I understand the problem.
All right.
Thank you. Good morning, members of the panel. May it please the court. My name is Nancy Baskin, and together with my partner, Jordana Kirshner, who is here with me, we represent the appellant, Kareem Suan de Felipe. There are 4 areas in which the trial court committed clear error. 2 of these relate to Mr. Suan's Fidelity shares, which were granted to him post-separation and purchased through a loan from Fidelity. These 2 types of shares are called NVCs. They have a 7-year vesting period, and they were entirely invested still at the time of trial.
Entirely invested? I
Entirely.
thought that I thought I read 20% were vested.
Nothing
No?
vested until
They
post-trial.
vested 6 months later, after the last day of trial?
That's right.
Okay, that's what I thought.
So
but I read-
there was a 3-year period of when they were not vested, and then 6 months after trial, which was 2.5 years. Thank you. There's a second smaller class called IEUs, which have no vesting period, immediately vest upon grant. They are often, it's a smaller category. The other 2 areas of clear error relate to the amount of support ordered to be paid to the wife.
So the IEUs vested upon grant, so they were fully invested as of the time of trial?
Correct.
And there are distributions, some people call them dividends, that had been spun off and paid out immediately before the trial, right?
Well, in fact, most of the distributions, also called dividends, as Your Honor notes, that come from the NVCs are in fact in the form of IEUs, investor entity units, as opposed to in the form of cash. So there are additional investor entity units that are spun out. All of those, any distributions and dividends, as I will get to, reduce the value of the NVCs dollar for dollar.
Yeah, but my preliminary question was,
Yes.
those had been distributed prior to trial.
Yes.
Okay.
And we do not dispute that those would be equally shared because they were vested.
Yeah.
As of time of trial, we don't have a dispute about that.
So do I understand then the appeal is really, so the first issue on the appeal is the Bacardi question, right? That doesn't go to the IEUs.
Correct.
Because they were fully vested. Only goes to the NVCs.
That's right, Your Honor.
Okay.
And so the trial court equally allocated those entirely unvested NVCs between the parties. Instead of applying the time rule coverture formula established in Bacanti v. Morton nearly 25 years ago.
And just pause for a second. You're not disputing that this first tranche of NVCs issued in December 2020 are part of the marital estate. You're simply saying, the argument is more limited to the proper valuation exercise, NAV at the time of the trial versus the if and when realized, right?
In essence, yes, Your Honor.
Okay.
The Bacanti formula does have 2 components. It has the what's in the marital estate, and then how should that be divided, allocated based on vesting dates. None of that was applied in this case. It was
But you're
just,
conceding that this tranche is part of the marital estate.
we don't object to this grant being part of the marital estate as long as the coverture formula is properly applied, that takes into account the fact that they're the vesting period and that they were entirely unvested.
Right, and so we're in a valuation debate, and it seems like, to me, reading the case law, in particular Adams and Bacardi, a trial judge has a huge amount of discretion here to decide the proper valuation model. Do you have a case anywhere in which a court relied on the if and when model and an appellate court reverse that for an abuse of discretion?
I don't have that case, but I do have the fact that we consider it to be based on the very clear dictates of both, give me 1 second, Your Honor, I apologize. The clear dictates of both Adams and Hanafi that the preferred and appropriate method of division is if and when.
Yeah, I'm sorry to be a pest, but I read that, and it's in a footnote. And what they actually say in the text is, indeed, judges are permitted to exercise their discretion to order the future recovery of payments of a partnership interest if and when received according to a formula fixed in the property assignment. Footnote, and the footnote quotes your point, is where your point is found. So the courts, this clearly says, if it's reasonable, a judge has the discretion to apply the if and when model. And it seems like here, the obvious reason she did it, the judge, I think is she, is that we don't have a track record of how much these NVCs are going to be spinning off to your client because he's only had them for a very short period of time. Where have I gone wrong in defending the trial judge?
Thank you, Your Honor. First of all, Hanafi did state that the if and when method should only not be used if present value is uncertain or current division is impractical. And here, neither of those is applicable. This notion of a track record of money being spun off or distributions being spun off from the NVCs is inapplicable here.
Why?
And the reason for that, as testified by the Fidelity Controller and Director of Shareholder Operations, any distribution made from those NVCs, anything spun off from the NVCs, will reduce that value of the NVCs on a dollar-for-dollar basis.
I get that,
And
but the big problem you're avoiding, at least from my perspective, maybe you're not avoiding it, but from my perspective, this is an artificial exercise because it's a closed environment. If there were a market value assigned to these NVCs, that market value, according to any economist and business valuation person, as explained very helpfully in Adams, is the future revenue from the Fidelity machine. In other words, this NVC gives all that the NVC reflects in an NAV, as I understand it, is a very narrow concept, the total income for that 1 year divided by the number of outstanding shares. But that's not the real value. The real value is going forward, you're going to keep getting that amount of money ad infinitum. Where am I wrong about that?
Okay, a few places, if I may, Your Honor.
Sure.
First of all, Adams isn't applicable here because Adams is a partnership interest. Mr. Adams continued to receive capital returns on his partnership interest. That's not what this is. This was compensation. He doesn't have any voting rights in Fidelity. He has no partnership interest in Fidelity. Secondly, this is the real value. It's the only value at this time. And going forward, and any future value going forward, where the value will presumably increase if Fidelity does well, and one hopes and expects it will, is post-divorce appreciation. It is no different in that respect from splitting Google stock. Google stock makes, somebody says, I'll take the Google stock at market price, and it may throw off dividends in the future, but that doesn't go to the value that is going to be bought out today, nor is it relevant that it may appreciate in the future.
I thought about that, and you used that example, and you also used the home example.
Yes.
Yeah, so, but the difference, I think, is that both Google stock and the house have a market value mechanism to reflect future value. Google stock today is priced to, I think, to reflect future earnings. And I don't think that these Fidelity NVCs reflect that. So
There's never a time, ever, where the NVCs will be valued based on their future potential. The NVCs will only be paid for by Fidelity at the NAV. Correct?
That's
At any time that they're redeemed, they're only going to get whatever the NAV is then.
Fidelity could not possibly predict its future potential.
And they're not.
And Fidelity, in fact, will only redeem those shares when it's time to redeem them, when our client retires.
At NAV.
At the NAV at that time, as it has been reduced by distributions over the years, dollar for dollar, and as it may have appreciated if Fidelity does well. But it would be unreasonable to expect Fidelity, or anyone else for that matter, to look into a crystal ball and predict the amount of appreciation that may occur in the future. They value it based on how they have done. It's done quarterly. It's an internal process. They issue it to all interest holders in Fidelity. It's a very above-board process, and that's what they redeem those NVCs at for every single employee when redemption.
I misunderstood something. I'm sorry, let me just get this out. I misunderstood, I think, what you were saying earlier. You don't want an if, as, and when distribution.
Correct.
You're arguing that was error under the case law, right?
That the only reason not to do if and when under Hanafi and Adams is if it's impractical or uncertain. It's not uncertain. We have a fixed NAV. That's the value.
You misspoke again. The only reason not to. You mean the only reason to.
No,
that's what you said earlier, and that's why you confused me and sent me in the wrong direction. You don't want if, as, and when. You say the value's known, and it should have been split right then, but it should have been split according to Bacanti. That's your argument.
It should have been split according to Bacanti, but it also should have been done, present value, not if and when. Present value, we had a fixed value as of date of trial. That's the only possible value. And the only reason not to do that is a flawed theory on which the court relied, although it was internally inconsistent because in its findings it credited the testimony of the Fidelity controller that the only possible value is the NAV. And so we had a certain value, and we had the ability to buy it out because my client was waiting for significant funds.
Judge Christopher credited the wife's expert, Mr. Sanderson, who said that the NAV doesn't capture all the benefits that flow from ownership of the NVCs, including distributions, dividends, and appreciation and value. Now, you may disagree with that, but that was a factual finding that she made and is entitled to a lot of deference from us. So doesn't your argument on appeal sort of come down to us having to sort of say the judge was wrong on making that finding?
Well, I think that was reversible error because I think the record does reflect in the findings that the court acknowledged in several places that the NAV, inconsistent with her conclusions, that the NAV was the only applicable value for those shares.
The testimony was that that's the only way Fidelity is going to redeem the shares at any particular times, according to the NAV.
Yes.
There wasn't a finding that, and the NAV therefore accurately reflects the long-term value of these instruments, right? That's a totally different question. No, the finding that she made was that the NAV is essentially this kind of internal bookmarking that Fidelity uses because these are kind of unique, not publicly traded instruments, but not that it actually reflects the full long-term value. And that's essentially the critical thing that you decide whether or not the Bacanti analysis applies or not.
Well, one of the issues that was problematic is that the wife's expert claimed that the distributions or dividends used interchangeably that may be thrown off increase the value of these. And in fact, that's just wrong. The Fidelity expert not expert.
Leave the dividends out of it because Justice Toone's question is really an excellent question. And his question is, even if you're right about NAV and how they're going to redeem it, there was an expert who testified that the actual value is something different. And the judge agreed with that. So you have to be arguing clear error because what Justice Toone is saying is, look, couldn't the judge decide because the judge agreed with that testimony that she'll do it on if, as, and when? And if she does it on if, as, and when, this problem goes away.
With all due respect, Your Honor, we believe that first of all, it is clear error by the court because, in fact, even the wife's expert, in contradiction of his own theory, acknowledged in his testimony that distributions paid out reduced the NAV. So we got that.
Distributions are irrelevant. Well, the question is whether this asset has to be valued the way you say it does, or whether it had greater value. If it had been put out on the market, as Justice Wood says, if it had been put out on the market, it would get a much greater value because people are going to assume that Fidelity's going to keep doing pretty darn well. And that would be built into the value of the stock. It wasn't there because of the way Fidelity did things. But that doesn't mean that the judge couldn't say, you know what, I'm going to say if, as, and when, because if I do that, I don't have this problem.
Here's the problem with that, Your Honor, and I think it is a huge problem. And that is that one of the reasons assets are divided at the time of divorce is because it isn't fair for one person to have to keep contributing post-divorce efforts to an asset that the other person sits back and enjoys the benefit of. That's a reason to divide assets at the time of divorce. The wife was free to take her share, her 50%, if it was 50%, of those NVCs and IEUs as of the date of divorce, invested as she saw fit for whatever future appreciation she wanted.
That assumes that the value cannot consider what every other valuation of stock does, which is how do I think it's going to do in the future?
Well, I think that to Justice Wood's point, it is not the case that a house valuation builds in possible future appreciation. That's not the way valuations are done. They're done based on comparables, on actual sales. Has nothing to do with future appreciation. That's the same thing with common stock. It's based on what the market value is then. You know, maybe there are some people who speculate and expect it to go up or down.
What's built into that is an assumption about whether it's not about where it is right now. It's what the market thinks is going to happen to that company in the future.
Well,
that's what they do. That's how it's valued.
Well, let's look at a house then. A house is valued based on current, and it's bought out in divorces all the time, and then someone invests their share in whatever they want to for future appreciation. That's no different from this, except the difference here is that our client is expected to keep working at a very high level and keep performing until he retires. You know, he's 42 years old now.
Your red light's on. There are other issues, and you may want to address some of them, and we've had a lot of questions. On Bacanti, what was the exact testimony? The testimony was it should be roughly what percentage of the stock?
I have the number. I have the dollar amount, but I don't have the percentage here with me, Your Honor.
But the percentage was based. Isn't the problem in applying Bacanti, and part of the problem the judge had, that some of these things vested immediately and some, so one piece of this, which is if you got distributions, it vested immediately, right? Which is different than an option or anything else. So you have something that vests immediately and you have other things that haven't vested at all. So you have, I mean, how did your expert explain to the judge how to deal with that problem? Because honestly, I read your brief and I didn't understand it until I read the other person's brief, that there was this sort of some of it vested and some of it didn't.
Well, that's because there are different components, and I think there is some complexity to it, in fairness. But in fact, anything vested, we have no issue with dividing equally. And what was unvested, we wanted to apply Bacanti to, because that's what Bacanti is in place for and has been in place for 25 years and has guided how this is done.
Let me just stop you there. So if I took that statement, anything vested would divide equally, that would mean that you could say, let's take the income and set it aside, and the income and any of the IEUs, right? And say the wife gets 50% of those into the future if we do if, as, and when.
Why would she receive?
Whereas the NVCs would have to have Bacanti apply.
So
why couldn't the judge have done that?
Well, because we don't divide future assets in divorces. We divide as of the time of trial.
They divide income streams separately from assets. These are income streams.
Well, the income stream of the IEUs, which are distributions, is reducing the NAV. So that would essentially penalize our client because he would be paying out at a NAV at the time of trial.
They were already vested, right? They were already vested.
Understood. No issue about at that time, but into the future becomes problematic because each of those distributions reduces the value of the stock that he has, separate from possible appreciation, which we would attribute to his post-divorce efforts, having, among other, So sorry, Your Honor. Among other
Right, I
things,
think it's
having
very
nothing-
complicated, and is there, and we'll have to think about it and try to figure that through, whether you're right or not. Are there other issues that you need to bring to our attention, because we've
Very brief.
interrupted you a number of times?
Thank you, Your Honor. I appreciate the time. The other issue is that, and it's, the court used to determine the wife's needs, the sixth financial statement she filed in this matter, which was a trial financial statement, instead of the first financial statement she filed in this matter, which was 2 months after the parties' separation, and which reflected the standard of living during the marriage. The courts have been very, very clear about this, most recently in the Young case, where the intention of support is to enable a spouse to maintain the standard of living that he or she had at the time of the separation leading to the divorce.
Read that. Waiver. It seems to me important here. Well, first of all, the wife's side says waived. At trial, there was no criticism of her expenses for her standard of living. Is that right, factually?
Now, well, we believe that while we did not expect the court to take into account, contrary to the applicable case law, the final trial financial statement, we didn't cross-examine because we didn't see it until the judgment came out.
So the problem, right, I get that. The problem is that now there's no, the wife didn't know that she needed to justify these expenses. And so that seems like a classic reason why waiver is an important doctrine.
So here's why we would say that that's not correct, Your Honor. 2 reasons. One, in fact, the objective has to be to determine the actual marital lifestyle. In this case, the wife increased her expenses by 25% over the course of the period of separation when she had unilateral decision-making, unfettered access to the marital estate. And so what she came up with in the end, and in fact the court acknowledged it was increasing the award above that, which we considered error as well, had something to do with the marital standard of living, but was significantly increased and was therefore unfair. Secondly, Your Honor, the court had the entirety of the record, had 6 financial statements before it in rendering these findings and decision. One would reasonably hope, I think, that they would all have been reviewed, and the court might have seen that over the course of those 6 financial statements, every single time during post-separation, her expenses went up, with one exception, to 25% higher, so that those were all documents that were in evidence. And finally, Your Honor, even in the Openshaw case, which I believe supports our position, because in Openshaw, the husband was asking that the separation period dictate the wife's need, and the court said, no, we're going to use her financial statement as of time of trial for the reason that there was a support order in place, and so her spending was restricted during that time. But the court's, which is opposite from our case, the court's point was we're trying to capture her actual expenses from the marriage, the marital standard. That's the same thing that should be happening here.
Counsel, doesn't the judge have the discretion to account for example, inflation that may have occurred between the time of separation and the time of trial, if the judge chooses to do that, in trying to place the wife in the position where she had been in?
I don't think there's an issue with inflation, Your Honor. I understand that.
So it could be something more, right?
This is 25%, though.
The defendant, the wife makes the point that this first valuation, the first standard of living estimate was at the time of COVID. And I think we all know that we spent differently during COVID. That seems like a not irrational basis to uphold the judge's determination.
Well, in this case, Your Honor, however, even if one looks at her mortgage representation in her financial statement, it's pure conjecture. It essentially says in her financial, I'm going to ignore the actual mortgage. Here's what it might cost me in the future, according to a quote I got, and it's $90,000 a year higher.
When did she say that? The last day of trial or sometime before?
In her financial statement, Your Honor.
Which financial statement?
That was the Both trial financial statements, fifth and sixth financial statements, Your Honor.
So sometime during trial, she said that, and you never made an issue of it until post-trial.
We didn't have the opportunity, we were done cross-examining her, and the court was very, very
Didn't
strict.
we call her and say, hey, you know, we've got brand new evidence here? Judge wouldn't have let you do that?
She would not have let us, Your Honor, I'm certain.
But you didn't try and you didn't preserve an objection on that.
That's
Okay.
right, Your Honor.
You've gone well over time, so we have your argument. Thank you very much.
Thank you, Your Honors.
We'll hear now from Mr. McKenzie, is that right?
Good morning. May it please the court. I'm Stephen McKenzie. I'm joined here at table with my colleague Andrea Pariner-Sweet. We represent Layla L. Yousef. I think the court just noted that the trial judge is afforded broad discretion in fashioning a division of assets and debts pursuant to 208 Section 34 and an award of alimony pursuant to 208 Section 53. After 7 days of trial here, the rationale and findings of fact was over a 47-page document, single-spaced, meticulously robust, and demonstrated an application of the law to both the property division and the alimony award. The rationale underlying the judge's conclusions for both the property division and the alimony award is not only apparent from these detailed findings, but also explicitly articulated and achieves a result where both parties are treated fairly and equally. And that's why we believe this court should affirm the judgment in its entirety.
Here's my biggest struggle with what the judge did is this concept of coverture. I'm no expert on coverture, but as I understand it, I'm wondering if it would have been at least reasonably possible to apply the principle of coverture to these NVCs. In other words, okay, these are going to be existing for a long time in the future, as long as the husband stays employed, which is, I guess, a big if. But why isn't it reasonable and maybe clear error not to apply the principle of coverture?
It may be reasonable, Your Honor, but here we have no present valuation of these future distributions. So I think that's what makes these NVCs a bit of a unicorn and more like the equity interest in the Adams case. I think just simply taking the NAV, this liquidation value that they call a net asset value, that specifically excludes in its definition itself from the materials that we had and what came into evidence, this future distributions. In Adams, I think the husband there...
I still don't understand why the distributions matter, because that's a zero-sum game. If there's a distribution, then they matter in one way, which is they vested immediately.
Correct, Your Honor.
But in terms of what they do to the asset value, they're a zero-sum game.
Understood.
Distributed, the NAV goes down.
Well, the NAV may go down. There's also a clawback provision in these documents as it relates to the NAV, the fluctuating NAV value. So I think they're...
Why are you conceding that? To my mind, one of the reasons people invest in stocks, one thing people look for when they're investing in stocks on the open market is the dividend. And the dividend, if it's annual and hefty and consistent, is built in to the value, the market value. So now the problem here is that we don't have a track record because I guess the Fidelity didn't want to talk about it. I don't know. But in any event, I think that if the dividend is regular and hefty, that absolutely is a part of the market value on the open market, not here. But the fact that in the accounting mechanism sorry, I'm going on too long. Why isn't that accurate?
I'm not conceding the fact that the value to the holder, one element of the ownership of value, one of these benefits of owning these NVCs is the distributions. I think during the course of the trial in 20 and 21, there was maybe $200,000 worth of distributions. The other thing that's very linked to this.
Can you say that again? How much the distributions were? How much?
$200,000.
Right. Okay.
And I believe in 2021 and 2022. But the problem here in the my sister mentioned Laurie Haley that testified from Fidelity, the head of shareholder operations, is that the distributions from the NVCs, they pump out these IEUs, these investor entity units. Fidelity raises a lot of cash, they need places to put it, and people who hold NVCs can also kind of get into this second investment opportunity. You have to hold NVCs, I believe, to buy into these Impreza entity units. Some of them you don't have to hold NVCs, but you know the distributions on those are speculative as well, and you can get distributions in cash and in shares. So as far as running this NAV value through a Bacanti calculation, and it's kind of Bacanti or bust, and nobody else, you know, on the other side argues.
I don't understand that. I mean, I really don't, and this is where, you know, you may need to convince me. I mean, it seems to me, the way I started thinking about this, there were two issues. One is whether, under circumstances where the vesting did not occur until after the marriage ended, whether Bacanti has to apply in some way, okay, or the judge committed error. All right, that's question number one. And question number two, as you've raised it, is sort of how is this asset, some of which your client is going to get, no matter what, how is that to be distributed to her? Should it be distributed at the close of trial, as the second time I've done that, as the husband says, or should it be disclosed if, as, and when? It seems to me those are two issues, and you can kind of divide them that way. But you got to deal with Bacanti. This asset had not vested, and yet your client got 50% of it. Is there any case that says that's okay?
I believe the Adams case says that's okay. Well, first off, I think Bacanti in and of itself says it's neither mandated or prescribed.
It says it's neither mandated or prescribed. That's true. And I suppose, see situations where a judge says, you know what, I'm not going to do it over here because I've made up for what Bacanti would have required me to do. Maybe that's what they're referring to there. But otherwise, the way I read Judge Cowan's opinion, she's saying if it's not vested, there needs to be some accommodation for the fact that the future work of the spouse outside of the marriage is what's causing that to have value. And you're telling me I'm wrong about that and the judge can just ignore the teachings of Bacanti? Because that's what happened here.
Well, I'd never say you were wrong, Your Honor.
I've been wrong many times, and if I am, you need to explain why.
What I am saying is that the right here was the right to purchase these, and that entire right accrued during the marriage. So, for instance, Bacanti dealt with the right to purchase something in the future. This was already purchased. The entire right to even begin to purchase this was accrued during the marriage. That was marital effort. I mean, I said there was multiple pages on this in a very detailed single-space finding.
What do you do? I get that, sort of, because it's a funny situation. I mean, at day one, it established no value, right? Because presumably he'd paid actual value, NAV value for the item, right? Through a loan.
By way of two loans, Your Honor.
Yeah. But what do you do with the fact that it didn't vest, and it would not vest until the husband had stayed at Fidelity for another 7 years? It completely vest.
Well, the vesting is tied.
Isn't that about the husband's future work?
I don't think he has to do any future work to have achieved the ability to purchase these 20,000 shares, and I think that's the distinction in the judgment and the rationale where my client received none of the other 20,000 shares that were received in December of 2022. I think these shares, the first tranche of 20,000, was a result of, and his ability to even become a qualified purchaser or an accredited investor pursuant to Fidelity's rules.
And this is obviously a retention tool for Fidelity, for its high performers, and there's going to be you retain people, you want them to be here for X number of years in the future, but you don't become entitled to them without having done work up to the point that you receive the NVCs, correct, right?
Correct.
So that's the distinction that the judge drew, is that sort of the 2020 NVCs reflected the husband's work at Fidelity up to that point, whereas the ones that were issued at the end of 2022 were somewhat different. That's the distinction she drew, right?
Yes, Your Honor. I think the 2022 came in after 6 or 7 days of trial.
Right.
When the parties have been separated since October of 2020.
But how do you square what you just said with what Justice Cowan said in Bacanti about options, which is to the extent that it's dependent on the future work of the spouse, whether or not that can be realized, there has to be some reduction that recognizes that. Isn't that what Judge Cowan said in Bacanti, or am I misreading it?
That may be what is applicable to options, but not necessarily these MVCs. Because there's no necessarily future work other than showing up to hold these, MVCs.
Showing up is real work.
Well,
I saw that in your brief, and I almost laughed.
I mean, you're both, it seems like these are both right. I mean, it's a reward for past service, but as Justice Toone says, it's a retention tool, but he can't just show up. He's getting this because he's apparently an amazing stock picker. Okay, sure. But they want him to keep picking the stocks. If he shows up and just starts drinking coffee every day, presumably he's going to have an employment action, and then if he gets fired, he's going to stop getting the NVCs. So it's not just showing up. He has to keep doing what he's been doing. But is that dispositive? In other words, I think Bacanti is much more, to use a technical term, squishy than other folks. If you look at footnote 9, excuse me, in footnote 9, of course, as discussed above, the judge could also find that the options should be deemed marital property despite the fact that they were given in part for services to be performed after dissolution of the marriage. So it seems like we're giving judges, excuse me, the tools to address complicated problems of valuation in the division of the marital estate. Speak to that.
Well, I think the probate and family court is a court of equity, so I don't think there's a one-size-fits-all rule here. And if the court, in its broad discretion, deemed that the time rule formula in Bacanti didn't apply, it could achieve a more equitable result, as it did here, in dividing the one tranche of 20,000 shares that were purchased in 2020, and my client received none of the shares for those that were received in 2022.
She didn't explicitly tie that, though, back to giving the 50% on the earlier one. I mean, that wasn't in her rationale. I understand your point, but she didn't say, you know what, I'm going to do some rough justice here. I'm going to give nothing for the 2022s, even though I probably could. She didn't say that.
But she said that there were findings, explicit findings, that the right to purchase these shares accrued from the marital effort of both parties, the non-economic contributions of Ms. El Yousef, and those contributions from Mr. Suan.
Those are findings that to the 2020.
So here's what Bacanti says.
Sorry, is it the 2020 you're talking about? Right?
2020.
Got it. Mm-hmm.
If the options were given for efforts expended before or during the marriage, they are part of the marital estate. If, however, the options were given for efforts to be expended after the marriage, in order to include them in the marital estate, the judge must determine whether the options were nonetheless given for efforts attributable to the marital partnership. Did the judge find that? Is there a finding to that effect?
Well, there's a finding that as to, if I could have a moment, Your Honor.
I was reading from footnote 7. Footnote 9, which Justice Woods read, refers back to footnote 7, turns out.
Well, I think the court found here, as it relates in relation to the footnotes that you are reading, that the right to the interest accrued during the marriage. And so the problem here is this is a purchase that already happened. And Bacanti's talking about a future purchase. You know, the stock option, the restricted stock unit is just simply a right to buy something at a fixed price at a fixed point in time. So I think that the distinction here, as it relates to Bacanti, is more about that this right to purchase and hold these NVCs already happened. And it was a result of the 10 years that the husband worked at Fidelity during the course of the marriage prior to his receiving same.
But more than that, I'm sure we're going to find when we burrow back down the second time, that the wife, and he was able to do that, able to work those super long hours in part because his wife held down the fort at home. And so that's the notion, the modern notion of these kinds of marriages, that's part of the concept. But again, that's not all this is for. It's also a promise that I'll keep doing that in the future. In other words, this is a hybrid situation, these NVCs. It's both a reward for the past, which the wife helped you with, and a golden handcuff to keep you coming back. Isn't that right?
Well, that might be true. Well, that is true, Your Honor, but the fact that there's like transferability restrictions by way of Fidelity for her to just hold them on her own, right? So if these NVCs are related to a NAV that's not just about Mr. Suan's individual performance, she's holding these, and if these IEUs, the NAV, which is set by these individual VC companies, which Fidelity doesn't know about until they're told, which makes these even more speculative, and I'd say more akin to the interest we're talking about in Adams. So that's how I would address that point.
Can I ask about, do you agree that the IEUs are not at issue in this appeal?
I'm taking the position that none of these are issues. The IE.
Okay, well, let's focus on the IEUs then.
The IEUs, they were fully vested, right? But
what happened to them?
So the proposed judgment of the husband was that somehow they take the NAV of these individual companies at the time of separation, and they also have a loan or a vesting schedule associated with them. But they only pay out, these IEUs are also very speculative. They only pay out at, when somebody stops working, or, if they're terminated, they get paid out. And then they may not get paid out in cash. They could still get paid out in promissory notes, maybe that extend 5 years after some termination event.
So wait. What has happened to the IEUs that have been invested so far? Have they gone, what has happened to them?
They're still there.
They're still where?
They're still in a statement of holdings. They're still, a holding at Fidelity.
Does the wife get them at some point, get a share of them, or?
They can't be transferred. She will get
The
her half is being held in a constructive trust by Mr. Suan.
For how long? How long does that happen?
Until their value can be recognized in some form or fashion. Either they get paid out by way of a promissory note and maybe some sort of coupon with
If he
interest.
leaves before they realize their value, do the IEUs disappear?
They do not. They do not. And Lori Haley who was the shareholder, testified to that. I had looked at that myself, Your Honor, and I have some.
You're well over time, and we have some other questions, so there may be, is there anything else you'd like to talk to us about?
Well, I would just say that the court is afforded, the trial court was afforded the same broad discretion in the alimony award. We do believe that was waived. I think there was raised to my sister.
So your sister says, but wait a second, the real problems with this arose at a time when I had no more ability to even examine the witnesses, because one of them was filed the last day of trial. One of these, the last statement, which I take it was had the most divergence from what prior expenses had been, was filed the last day of trial. Is she wrong?
I think that if you're determining most by the preliminary draft financial statement that was filed in 2020,
Yeah.
that was marked as such and included a footnote that said that this is not indicative of the
Okay, so
spend
let's
rate.
take that. When did trial start? 2022?
September of 2022.
At that time, did you file another financial statement?
I believe we filed 6 or 7 financial statements, Your Honor, every day of the trial.
So let's take the one at the beginning of 2022. Did it have the problem that your sister identified of anticipated mortgage costs?
I don't believe it had anticipated mortgage costs on it, Your Honor.
When did that turn up?
I think that was either, I know it turned out before, I think it was the second to last day of trial, anticipated mortgage costs, or maybe in the middle of trial, because I remember having a hearing about striking some of the
Second to last day of
language.
trial, how much opportunity did they have to address it then?
They could have addressed it right there with the court. I mean, I don't know what would have happened. My sister had mentioned that.
But, here's the problem. I mean, so you start trial and you've got expenses, right? Which is great. This case, I think, I will commend the parties. It appears to me, at least, sort of reading the briefs, that there's a lot less of the sort of back and forth with respect to this kind of thing than we sometimes see. So, but at the beginning of the trial, they have a set of expenses. When they change mid-trial, potentially after your client has testified already, that's an issue for them, right? That's a problem. And then to say, oh, you waived your objections to that. I mean, they put it in their post-trial briefing. They would have addressed it in closing if we did an ordinary trial, right?
Well, the issue here, Your Honor, too, and it is in evidence, is that the parties filed a stipulation for temporary orders in about December of 2022. It's at Volume 1, page 86. And they agreed to maintain the financial status quo. So we're talking about a very lengthy period of time in which the parties were in front of the court. If at any point in time my client's spend rate was somehow excessive, then there was an opportunity to address it at every motion
hearing. The problem you have is that the judge took, or the problem they're identifying, I don't know if it's a problem you have, it's a problem they're identifying, is that the judge took numbers that showed up at the end of trial when they didn't have enough. And all we're talking about right now is the waiver issue, right? Isn't that a little bit aggressive to say they waived it when they put it in their post-trial briefing when they only saw it toward the end of trial?
Well, in terms of the waiver, they could have filed a complaint for contempt if they had an issue with those expenses over the course of the entire pendency of the proceedings, and they never did. So if the financial status quo wasn't as such that was delineated on financial statement after financial statement, and it was never addressed, I think it's a little bit inaccurate to say that there was no opportunity to address my client's financial statements because of somehow her, you could file post-trial pleadings on it. You could file a motion for reconsideration.
They say the law is that you have to determine the alimony as of the date of separation. Are they right or are they wrong?
I believe they're wrong. I mean, I believe Openshaw says that's wrong. The
Openshaw, you didn't cite that in your brief. I have to tell you, the briefing on this was, on both sides, was thin. Openshaw is where I'm going to get my help.
43, page 43 or 44 of your brief, I think. Can I ask? Sorry, go ahead.
Sorry. Well, just on this point, Young says that under general term alimony, that the evidence needs to focus on the standard of living at the time of separation, right? But that's a little bit different from expenses. Wouldn't you agree with that?
I do agree with that.
And the judge sort of made a finding that there was no testimony as to whether your client's expenses in 2023 didn't relate to her lifestyle as of the time of the marriage, right? Now, is that an issue that they could not have been able to flesh out at the trial and only in their post-trial filings, or was there an opportunity for them to sort of address that point during the trial?
I think over the course of the 7-day trial, they had an opportunity to address any and all of my client's expenses as enumerated on all of the financial statements. How they chose to spend their time was how they chose to spend their time. But the idea that there was a lost opportunity to discuss expenses on financial statements, I just think is a little bit of fantastical.
Can I just, on whether the judge made a clear error on that particular point, drilling down for a second, at page 16, I'm focusing on the cost, the weekly/monthly carrying costs for the house. It's bizarrely unclear, but page 16 of the judge's findings, she says $6,800 a month in interest because there is no principal, and then $4,400 a month. And we're talking about a month for taxes and insurance, okay? Those are the three things we pay for. But then, so you divide, so that's whatever it is. And then you divide that by 4.3 to get a weekly amount, and that weekly amount has no correspondence to the wife's, according to the chart here, $3,100 a week for mortgage, real estate, and insurance. I'm just trying to figure out the basis for who's right, who's wrong, the judge or... And how much weekly are we talking? Is there something else that I'm missing?
Well, I don't even think the judge took the expenses as, in their entirety from my client's financial statement. I believe my client's financial statement had around $13,000 or $13,200 a
Right,
week.
but the judge broke it, I'm sorry, not the judge. It is broken, well, first of all, the judge says what the judge says on page 16 of her findings. First question is, where did she get that? And second question is, the wife in her brief, sorry, I strike that. The husband in his brief breaks down what the wife is claiming on her financial statements, and it's much more. Was I clear about that? I apologize. That's what I'm trying to say is the wife seems to be claiming much more for interest, real estate taxes, and insurance.
It was labeled as an anticipated expense if she retained the marital home and had to get the husband's name off of the mortgage and refund.
Even on the first financial statement back in December of 2020, that's what you're saying. Even then, she was
I
anticipating.
don't believe it was on the first financial statement in December of 2020 because that was a preliminary financial statement filed at the onset of the proceedings and didn't have anything about anticipated housing costs that may result after the course of.
Okay, thank you, counsel. Thank you both. I'm going to end it here. Obviously, we've gone well over time because it's another complicated case, and we appreciate both of your arguments. Thank you. And the last case, Capalupo against DALY, 24P 751. You're Mr. Sheehan?
Good morning.
Welcome. Sorry that you had such long arguments, but we only have 3 today, so we're going to be done early.
May it please the Court, Bill Sheehan for the plaintiff Wayne Capalupo. The plaintiff and the defendant's decedent, Ronald Peredna, made an oral contract on September 26, 2018 for Mr. Capalupo to purchase and Mr. Peredna to sell following entities and assets for $2 million. First, all of the stock in Christie's Beach Pizza, Inc. Secondly, all of the membership interest in 11 Broadway Holdings, LLC. Third, real estate at 5 Broadway in Salisbury. And fourth, real estate at 2426 North End Boulevard in Salisbury.
So I'm going to come out firing, Mr. Sheehan. With respect to those first 2 entities, they held real estate.
They held real estate, that's correct.
And the real estate was the most substantial asset of each of them.
I'm not sure that I would agree with that, Your Honor, but there's certainly an element of each of them, and certainly with respect to 11 Broadway Holdings, that is true. With respect to Christie's Beach Pizza, not sure that I would agree that the most substantial asset of that entity was the real estate in Hampton.
But it was a
Hampshire.
substantial asset. There was real estate.
There was.
So is there any case that's going to help us with the problem that you had at summary judgment, which they argue in their cross appeal? It's going to tell us that the statute of frauds doesn't apply to what you claim is an oral contract to sell real estate.
So what the statute, with respect to the LLC, we're relying on Chapter 156C, Section 38, which specifically says that a membership interest in an LLC is personalty. We rely on case law for the proposition that stock is a personalty as well. And there's no distinction that I have found in any of the cases that suggests that because a corporation whose stock is being purchased somehow holds as one of its assets, even an important asset, real estate, that somehow that changes the nature of the transaction such that it falls within the statute of frauds.
So if I'm going to buy, so if somebody takes a piece of real estate and then folds it into a corporation which has a single asset, which is the real estate, which I suppose could happen, an oral contract to buy that corporation would not be subject to the statute of frauds.
That's correct. If the,
Any case that says that?
I have found no case, Judge, that addresses that issue either way, that with respect to a corporation, as you've just identified, as to whether or not, depending on the form, I recognize that it's the form of ownership. It's the
I mean, the briefing on this at summary judgment was very thin, and I understand you were responding. You were not the mover with respect to that, right? But do we have how do other jurisdictions address the statute of frauds? Do we know in that context? It seems to me this is a huge legal issue, just sort of right there, in the middle of this case. Because if you can get around the statute of frauds by putting things in corporations, I don't know that anybody gets around the statute of frauds in this way, frankly, because oral contracts to buy a business are pretty unusual, it would seem to me. But it just seems like a very odd thing that we're enforcing an oral contract, the principal thing of which is to buy real estate.
Your Honor, I don't know exactly how better to answer the question that you've asked.
I asked you whether you knew about, I'm sorry to be kind of wandering a little bit, but I asked you about whether you knew of law in other jurisdictions.
I don't, Judge. I've not looked at that. But the statute of frauds in Massachusetts specifically talks about, as applied to this case, a contract for the sale of real estate. And in this instance, we have a contract that is made up of a number of component parts, two of which are pure real estate, but two of which are not. And that really ties back to the two cases that we rely on with respect to...
I'm familiar with that. I get that point.
So I have a simpler question about the factual question about the meeting of the minds here. You have two apparently sophisticated business people, with one of whom has 500 people behind him, lots of lawyers and accountants, and it's primarily at that point a real estate deal. The major component is the real estate anyway, or a significant component, and they both therefore know that in order to make this legally binding, there has to be a writing, and yet there is no writing. And I get the theory. The theory is, well, they had a meeting of the minds and they were going to generate the documents afterwards. But how is the jury possibly wrong to conclude that, well, until they had that writing, which they both knew they needed, there hadn't actually been a meeting of the minds? That's what I, right away, can't get past.
Well, the reason that that there was no writing is that Mr. Capalupo basically acceded to the nature of Mr. Peredna, who was an old school guy whose handshake...
I read all of that, and that's not compelling to me. Of course, there had to be a writing, no matter how old school Mr. Peredna was. I understand the claim from Mr. Capalupo is, and I don't mean to be too dismissive, a handshake. That's what he testified to under oath, and the jury could have believed that. They didn't believe that. But what I'm suggesting is that they both knew, no matter how old school they were, that they had to put this in writing eventually for it to be binding, right?
They did.
Right, and so how is it that Peredna isn't sitting there thinking, okay, well, until we've got it written down, I've got no, assuming that conversation happened at all, that handshake happened at all, until it's written down. How can you reasonably infer there's a meeting of the minds until there was a writing for this primarily real estate deal?
Well, the four key elements for us to establish that there was, in fact, a meeting of the minds, that there was, in fact, a contract made on September 26. The first was the objective reasonableness of the price that was the subject of that contract. We were not allowed to, the jury was not allowed to consider the price of that contract as to determine whether or not there was, in fact, a contract. And that was a huge error on the part of the court. We've cited the principle under corpus juris secundum that there's no question that that was error. And it was important here because we were trying to enforce an oral contract. The second piece that was very important to us, insofar as trying to corroborate the oral testimony of Mr. Capalupo, was that there was a reason for Mr. Peredna to want to sell and sell as he did. And that was that he had grown wholly dissatisfied with the two managers to whom he had left that property, those properties, in a will in 2014, and he learned that they were stealing from him. And so he did not, under any circumstances, want those two folks to get that property, or those properties. That's why he sought out Mr. Capalupo. The evidence is uncontroverted that in 2017, he sought out Mr. Capalupo to begin these discussions, and that they had those discussions. The third key piece was that Mr. Capalupo was a logical buyer in the mind of Mr. Peredna, in addition to just as a matter of fact, because the two of them shared a specific love for and the importance of Salisbury Beach. And the fourth item was that this contract was partially performed. You talk about, well, why would a jury have thought that these parties would have made an oral agreement for something so important, $2 million?
Did you put in physical evidence of the keys? Were
Yes.
they put in?
Yes, the keys were introduced into evidence. The sheet on which the alarm codes were written were put into evidence.
But
And-
all of that, accepting that the jury believed all of that, and some of it depends on Mr. Capalupo's credibility, but assuming the jury accepted all of that, the jury could still reject, because that's not the central question. All of that can be true, and there can still be no meeting of the minds. It could be true that they had these conversations with all the preliminary things that you're talking about, and there could have been the delivery of the box of records and keys, and it still could be the case that, reasonably, that Mr. Peredna had not yet achieved a meeting of the minds, and Mr. Capalupo had not yet achieved a meeting of the minds. And the lack of a writing still creates this question, had there been a meeting of the minds, even with all the things you just went through?
And that was the first question that was submitted to the jury. There's no doubt that we faced an uphill battle in the sense that we were claiming an oral contract.
Right.
That's why all of these evidentiary issues and errors that the court made our ability to prove our case impossible. That's the reason that it's so important here with respect to these very important evidentiary issues that I want to talk about a little bit today.
So the question is materiality. Right. Materiality is the issue, right?
Sure.
Right.
Absolutely. And the standard here is if we had been allowed to introduce the evidence that we sought to put in, or had been able to exclude evidence that was wrongfully admitted, might that have had an effect on the jury's decision? And I would suggest to Your Honor that the answer to that question is clearly yes. The most important one being the reasonableness of this price. It only makes common sense that if someone is claiming an oral contract for a sale of assets for a price of $2 million, that if those assets were in fact worth $200,000 or $500,000, or were in fact worth $5 to $10 million, that it would be most unlikely that there had been a meeting of the minds, that there had been a
The
contract.
value is actually in front of the jury. Am I right about that?
I'm sorry?
The value that the defendant received from appraisal of the two properties was in front, actually, is it the two properties or the four?
There were 4 properties that were appraised, Judge. The total value of those properties was just under $2.5 million. To your
That was in front of the jury.
It was in front of the jury, but the judge was very, very careful to say over and over again that you cannot consider the value.
Over and over again? I saw the one place where she did. She did it more than once?
She said it 3 times. She gave a limiting instruction when we started talking about the value of the real estate. Said you cannot consider this as determining whether or not there was a contract. Then when we talked about the value of the personal property, she gave another limiting instruction. You cannot consider the value of these assets in determining whether or not there was a contract. We objected.
I'm sorry. I don't quite understand this point. I mean, you might have material arguments for your other objections, but for this one, how does the introduction of the appraisals were done the year after the negotiations, right? And you say neither of these gentlemen needed an appraisal because they knew the value of the property. So how exactly does this after-the-fact appraisal tend to show that the parties formed a contract?
Because it ties back, Judge, to the objective reasonableness of the price. If the parties were, if we were trying to prove a contract price, a contract at a price of $2 million, and these assets were worth much, much less than that or much, much more than that, it would be logical to conclude that there was no contract. If on the other side, on the other hand, as here, if the price that was set forth in the oral contract is consistent with the actual value, it is more likely that the contract was in fact made. That's
I mean, it's about a $500,000 off, right,
But
between the two,
well,
right? So it wasn't really that close, but I
Well,
mean,
but
can't you just guesstimate what you think? I mean,
but
I just don't quite understand, like, why do you need an appraisal to sort of establish this element, you know?
Well, we had to establish the value of those assets, and happily in this case, the value of those assets had been determined for another purpose. They had been determined as of 12 days after the contract was made. So we had excellent evidence as to what the actual value of those assets was. The other thing I want to add is that the record was clear that the reason that price was not $2.48 million as opposed to $2 million was there was a discussion between the two gentlemen, and Mr. Peredna wanted it to be a buyer-unfriendly, seller-friendly arrangement whereby potential liabilities would have been picked up by the buyer. So that's why there's a little bit of a difference in price.
Stock sale, not an asset sale.
I'm sorry?
It was a stock sale, not an asset
It's an asset sale, exactly right.
Right, I have a different question about this post-death valuation for the estate. It's a subjective exercise. I think it's tricky and maybe unreasonable to say that this is the objective truth. It's just a number based on, the truth is what the market will bear. And there's another guy out there saying he'll pay more. But in other words, it's not, I think, necessarily the case that a jury, and in fact it's clear that a jury would have been free to reject this valuation because somebody who wasn't actually considering buying these properties valued them at X. In other words, it doesn't seem that it's necessarily going to be probative to a jury.
Well, but appraisals are just that. It's a determination of what a reasonable buyer would, and a reasonable seller, what they would settle upon as a price. So that I think is the best answer for me to that point that you raised. That's exactly what these appraisals were. That is, what would a reasonable buyer, a reasonable seller agree on as to price? And if that price, if that value is close to what the price was, as we said in the alleged oral agreement, it would be more likely that that deal had been made.
On that point, correct me if I've got this wrong, but the original alleged agreement was for all of this property at $2 million.
Correct.
Plus the pizza businesses. Then, at trial, it became, you know what? I'll give $2 million for just the pizza businesses. Forget about all the other property. And thinking about that specific, I think I've got that right, that when we get to the question of the reasonableness of the price that they had agreed upon, suddenly it seems like the original agreement was kind of crazy. If he's willing to pay $2 million just for the pizza business, why was there an agreement to $2 million for the pizza business plus all the other property, if you understand my point?
The other assets were of very limited value. Okay. That is the two pieces of real estate.
They were appraised at what, about $500,000 total?
They were.
All right.
I think we have your argument, counsel. Thank you very much.
Thank you, Judge.
And we will hear now from the defendants. Mr. Feynman?
It's correct, Your Honor. I think it's still good morning. And
It is.
My name is Michael Feynman. I represent the defendant, CAMILLE MIRIGLIOTTA DALY, as personal representative of the Peredna estate. Mr. Shadal is also here representing the interveners, although he's not going to argue. I would like to focus first, if I may, on the summary judgment issue, because I perceive that as a legal matter to be critical, not only for this case, but for cases going forward. The judge, I think, made an error in failing to grant summary judgment as a whole. The case itself, as a result, shouldn't have even had to get to a jury. The undisputed facts, and some of which were reiterated and emphasized at trial, were that the assets that were the subject of the alleged agreement were to be purchased as a package. There was no divvying up, there was no separating, there was no individual allocated purchase price. The two assets are clearly, purely within the statute of frauds. The court, when the court denied summary judgment because of the reasoning or the language that's contained in the Rand v. Mather case.
You don't think, I mean, is this, so there are two ways you could argue this. You could say, I think the whole thing was indivisible. We couldn't shear off. It was inappropriate even to shear off the two real estate assets unrelated to Christie's. Or you could argue, you know what? Even if you could shear off the two real estate assets unrelated to Christie's under the case law, it's still a contract. They're trying to enforce a contract to buy real estate. Which argument are you making?
I made both, Judge. I argued at time of trial, and part of the question that you asked of Mr. Sheehan was that if a corporation goes to sell its own asset, its own real estate, the subject statute of frauds does apply. Here, and we pointed out to both the jury and to the court.
But he says that's not a sale of the real estate asset, it's a sale of stock. Stock is personality, therefore this doesn't fall within the plain language of the statute of frauds. What do we do with that?
Again, the court could have asked the jury, which never happened, whether or not that was a sale of real estate or a sale of stock.
No, it couldn't. Maybe the judge could have asked the jury, but whatever the jury said would be irrelevant.
Yeah.
This is a question of law, counsel, and I got nothing. Like, I looked at the summary judgment briefs this morning, and it's a pure question of law. Does the statute of frauds apply to a sale of stock where that stock involves a corporation that owns real estate?
I could find nothing on that, Judge. I could find
Not including in other jurisdictions?
I did not see anything on that. But getting back to the summary judgment issue, the opportunity for contrivance is too great to allow by looking at what items are the subject of an alleged agreement, as opposed to the terms of the agreement. The Fairhaven amusement case that I cited looks at the way the contract itself was structured. There were prices allocated, and in Fairhaven amusement, the damages claimed by the plaintiff were a fixed sum.
Do you think he, meaning your brother, can't solve that problem by simply saying, sure, take the real estate out and we'll pay the same price?
Well, that's what he attempted to do.
Why doesn't that solve the problem, though?
Because, again, it gets into, ever since law school, what we've always been taught, the court does not make an agreement for parties. It takes their agreement and enforces whatever it is. Their agreement was a package. That's undisputed. Mr. Capalupo reiterated that at trial twice. So why should the court...
Allowing them to do that should not, this is another legal question, I think. I mean, I know that it was going to be sent to the jury because of this word unjustified, which I think is in the Rand case, but you're putting it out there as another legal question, which is whether or not, as a matter of law, this was indivisible. This contract was indivisible.
And I believe it is. Again...
Doesn't that depend on the facts?
The court should not be in a position of deciding what the contract is between the parties or evaluating the quality of the contract or the prices.
That's not what's happening because, I mean, I do understand. I think your argument comes down to, I don't want to put words in your mouth, but I think what you're saying is, look, this is, the contract was for, as nobody contests, that if there was a contract, it was for four items.
Yes.
And you can't avoid the statute by the expedient of saying, we're going to throw these out of the boat and just keep these. same price. That's rewriting the contract?
As I see it, yes, Judge, it is. The parties had agreed that it was a package. They'd never said that these pieces are divisible. In terms of getting to another issue on the appeal, and the issues of exclusion of evidence, some of the evidence that came in as to the existence of an agreement between the parties, with regard to Mr. Capalupo's own conduct, all of which came in without error, was sufficient for the jury to find that there was no agreement. He performed no appraisal for any asset. He didn't inspect any asset. He had no financial information.
Efficiency question. It's simply a question of whether the exclusion of evidence may have had an impact on the outcome of trial, right?
And I believe
Aren't there at least two, really, I want you to address two significant evidentiary problems, okay, as far as I see it. The first one is the evidence that the value was $2 million. You even put in evidence from somebody that he was ready to put in 4, which made that evidence all the more important, that there was actually objective evidence that $2 million was roughly what it was worth. So that's number one. Number
Yes.
two is, and this one really bugs me because I'm a lawyer. Your client, you, on behalf of your client, told her, don't testify. Invoke the privilege with respect to communications that you had with Mr. Peredna.
yes.
And then at trial, you put him in. And he objected quite rightly. He said, look, I didn't even have a chance. I don't know what's coming. This is total surprise at trial. So address those two because those are problems for me.
Well, let me start off, I'll start off with the value issue first because I think that's easier. The value issue, the judge did not say that the jury could not consider value. The judge said the jury could not consider value of the appraisals until we got to the injustice, sort of a second phase, if you will.
Well, the judge instructed that evidence of the appraisal was not to be considered as to whether the contract was formed. That was
Correct.
the exact, and that's what you asked for.
Correct.
Is that correct?
It was correct, Judge.
Why?
Those appraisals didn't exist.
That doesn't matter.
And in addition,
No, wait, let's just start with that one. Why does that matter that they didn't exist? They are objective evidence as to what the value was at the time.
Your Honor, even in the prior case that was before this court, value is a matter of perception. What was really involved.
Yeah, and when an appraiser puts that evidence independently, this wasn't even the plaintiff's evidence, this was what your client put together. That's relevant, isn't it? I mean, we're only talking about relevant.
Again, I don't see it as relevant because it didn't exist until after Mr. Peredna died. It didn't even exist, these appraisals. So the parties...
Isn't the appraisal effective as of, I think, 8 days after October 4th, right? October 12th or whatever it is, I guess the date of death, right? Mm-hmm. Isn't it evidence from which a jury could infer what the value of the property was at the time that they entered into the agreement on September 13th, 1918, or 2018?
Could they have used that information to determine the existence of an agreement? Again, Judge, I would say no. And I say no because those appraisals didn't exist. The values that were being discussed between the parties to determine what they wanted, what they were trying to do, is what was relevant. Mr. Peredna, there was discussion initially asked, according to Mr. Capalupo, unfortunately Mr. Peredna is dead, wanted initially $3 million. But Mr. Capalupo said, I'll give you less unless you give me more financial information. And after the agreement alleged to have taken place, he gave him more financial information.
There was testimony that Mr. Peredna told his accountant that he wanted to get the value of the assets for $5 million, right?
That's correct.
So I think my colleague, I guess it's a pretty good point of sort of if that comes in, why can't
I'm sorry, we're going to have to take a short break right now, but you've got your 5 minutes here and probably a little extra, okay? I apologize for that.
It's
It's unusual, but we got to do it.
Thank you. Thank you.
Session, please be seated.
Apologize. You've got more time than this.
So my question was basically, if the door is opened with the testimony as to Mr. Pridden, I think it's worth $5 million, why can't the other side say, no, it's, the money, the amount that we were discussing is more in the ballpark of what it was actually worth?
I suppose that Mr. Capalupo, as an experienced real estate investor, his experience was laid out in spades at trial, could have said what he thought it was worth. He didn't. He could have.
But there's also the your introduction of the original purchase price, and I think you argued that to the jury in closing argument. So if it was error, increasing the error. So it's combined points.
I'm not sure I follow you, Judge.
You introduced the original purchase price of the property and then argued to the jury, in essence, look, this, if you look at that original purchase price, this is long time later, there's no appreciation. If you look at this $2 million price, that undermines the likelihood that they would have agreed to $2 million.
I did argue that. That's at page 23 of my brief, where I pointed out that the historical cost of the properties that were the subject of the alleged agreement was $1.9 million, not including the value of the pizza business.
Right, but to Justice Toone's point, doesn't that open the door to make it much more important to have these appraised values after the fact?
Well, and again, my point is that these historical costs were known to the parties, or they existed prior to the death of Mr. Peredna. The appraisals didn't exist. As to the issue of the attorney-client privilege and the claim of that, the appellant's brief makes a point, or tries to make a point, that these claims of privilege were replete throughout the deposition. There were 2 full days of deposition. The portions of the transcript of the relevant part appear in volume 9 of the appendix at page 65. Out of 2 full days of deposition, 4 pages of deposition transcript of attorney-client privilege going to the issue that came about at time of trial. The marked up will came in over our objection. I didn't see the relevance of it. I still don't see the relevance of it. There was an issue of, it was introduced as being as to the state of mind of Mr. Peredna. State of mind as to what? His intentions with regard to the interveners? It had nothing to do with his state of mind with Mr. Capalupo. So it came in for the purpose of his state of mind with regard to Mr. Capalupo. At that point, as far as my position was, is that the plaintiff put that matter at issue.
But you don't open the door to violation of attorney-client privilege, right? I mean, you can if there is a direct attack on the attorney-client relationship, perhaps, but that's not just because there's other evidence that's brought in regarding intentions. The whole case is about the intentions of the parties. That doesn't mean that suddenly you get to say, oh, now we get to disclose otherwise privileged communications, right? I don't think the opening the door argument justifies what happened here, and particularly since you closed the door at the deposition. Now, Attorney Daly gets on the stand and sort of starts telling a story that is contrary to the other side's position in the case.
Well,
seems very damaging.
Well, the court, as you've indicated, you say that I closed the door at the time of the deposition. I'd call the court's attention in the appendix, volume 9, in that.
What are we looking at?
I'm looking at, it starts at page 65 of volume 9.
Are we looking at the deposition transcript?
Yes.
So the deposition transcript of your client was in the record?
It was marked for identification as part of the objection by the plaintiff to her testimony. And so with regard to that,
So the argument you're about to make, counsel, is not in your brief. As I understand it, I saw nothing that makes the point that you're now making, which is, as I understand what you're about to tell us, because I wondered about this, hey, actually, he never tried to ask the questions that would have gotten answers to what she testified to at trial.
Well,
Is that what you're going to say?
I'm trying to address the court's question.
Is that what you're
It
gonna
is
say?
not in my brief. It is not in my brief. I agree. There were questions asked. The deposition took place 2 years before trial. To the extent that counsel felt that there was, that the door was open, and the door was partially opened at the time of deposition, he could have pursued that further. I didn't see that entire line as relevant.
How many times, when we go read this transcript, which unfortunately I think maybe we'll have to, how many times did he ask a question about a privileged communication where the privilege was invoked? And how many times did he ask a question about privileged communication where you allowed her to testify?
I would say, well, I can't give the court a number, but I can say that starting at volume 9, page 65, for 4 pages, is the entirety of any dialogue pertaining to the issue of the plaintiff's appeal. That's 4 pages worth.
4 pages of objections, or 4 pages of you not allowing
It was
privilege.
It was question and answer and some minor dialogue.
Okay,
And
but
that's what-
you're essentially saying, no, don't answer that, it's privilege, don't answer that, it's privilege. For
I
4
could-
pages, that seems actually quite a lot in deposition world.
Yeah, I could give the court an example of some of the dialogue that's discussed in here. If I may just find it again, hold on.
More importantly than the fact you didn't make this argument in your brief, you didn't make this argument to the judge.
My argument to the judge is what's contained in my brief, was
Right.
that the plaintiff put it at
The door
issue.
had been opened by what your brother had asked. Not that, hey, Judge, I never invoked the privilege with respect to these things that I now want to ask her about.
Well, I don't claim that I didn't invoke the privilege. I'm not going to lose my credibility with this court by saying that. I did invoke the privilege. I may have been a little bit lazy, not lazy, but not as diligent as I could have been.
I don't believe you were lazy, counsel.
Thank you very much. I appreciate that. My point is, as raised in my brief and as argued, is that the plaintiff himself waived that objection and waived that issue because on redirect or cross at volume 6, pages 43, 46, 47, 59, 62, and 63, at trial, the plaintiff questioned her about attorney-client communication without objection. It was waived at trial. And granted...
After you put her on in direct and got her to testify to attorney-client communications, all right?
Admittedly.
Okay.
And Mr. Capalupo's counsel did object when Attorney Daly began testifying about these communications.
He did object.
And there was also a sidebar.
He did object.
Second okay.
And again, my point is that none of this, all of this, it was not... I don't want the court to leave with the impression that this was a trial by ambush. It was not. I did not anticipate that this marked up will that was marked up months before the alleged agreement, marked up a copy of a will that was marked up months before the agreement, would ever be an issue for trial.
But didn't, I mean, just in terms of how material the content was of what Attorney Daly testified, she essentially said, Mr. Peredna told me all these things about how much he loved the employees, right? Sort of, it goes against the theory of the case in that he didn't want to give the property to these employees because he didn't trust them anymore, right? And her testimony kind of went exactly counter to that.
Well, that's true. And other testimony was that Mr. Peredna had reasons to mistrust one of the two individuals, not both. There was never any allegation about the second of the two individuals, ever. And again, my point is that with regard to the finding that there was no agreement and the extent of evidence that supported the fact that there was no agreement, unobjected to evidence of Mr. Capalupo's own conduct, that the error of admission of her testimony would have been harmless. I don't see that it would have changed anything.
Okay, so that's a prejudice argument, and I understand that. So we have your arguments. We've allowed everybody to go over today. I'm sure some of my colleagues would think that that is heresy. I don't, because each of the cases that we heard today, as those who have been sitting here probably know, they're pretty darn complicated, and they had things to them that we had to, and this is our chance to do it. So I apologize in one way, but not in another. I thank everyone for their attention. Thanks to our court officers, and we are adjourned.
Thank you very much.